All right. Hello, everybody. Welcome all. So for the sake of time, we have kind of a lot to get through in just a short amount of time. We're going to go ahead and get started here right at noon. And Cece Lee will be kind of manning the chat. So if you have questions, you can pop them in the chat. Just kind of general Zoom etiquette if you want to keep your mic muted, that's always a good idea. And towards the end of the session, we'll have some time for Q&A. And you can kind of, again, let those sorts of things accumulate in the chat. Certainly, if there's anything logistical, Cece will be able to help you out. So I'm Amanda Pratt, and I am working on the data and curation team at the nonprofit Psychedelic Prior Art Library, Porta, Sophia, working on the archival end of things. And if you're here, that probably means that you're at least somewhat aware of the ARN or Archival Researcher Network initiative that we've been working on, and hopefully also interested in participating and or at least kind of learning more about Porta Sophia today. And so while the Archival Researcher Network, we're really envisioning that as a great opportunity to really activate historical expertise to make a difference in the system, that the system being the patent system. Really, for better or worse, this system stands to shape the landscape of access for the future of psychedelics. When developing this initiative at the same time, we kind of recognize that it's a bit of a steep learning curve when it comes to understanding the nuances of patent law, for instance, and some of the other facets of what we do at Porta Sophia. So we're really happy to have the opportunity to engage with folks that are interested in what we're up to, and at the same time, kind of provide this series of primers that'll hopefully give you a better sense of how you might be involved. So again, this is the first of 4 information sessions about Porta Sophia and things that are helpful for you to know to kind of understand what we're doing in order to be able to engage with us in the Archival Researcher Network. Cece, if you could go to the next slide. Just to give a sense of what's coming. This is the first of 4 info sessions, and so the information is there. I'll just really quickly in the chat. You can register for all of these at our landing page at portasophia.org/archival-researcher-network. And so next week, the data team will be kind of pulling back the curtain on what we do, and specifically more into the nitty-gritty of what makes Porta Sophia work, and sort of how the Archival Researcher Network might be involved in that. And then next Wednesday, so a week from today, Chuck Raison will talk about psychedelic science as relevant to what we're up to, and specifically thinking about archival prior art. And then last, but certainly not least, Luke Rickert will be talking about psychedelic archival research on February 23rd. So yeah, welcome everybody. Good to see some familiar faces for sure. And so again, this is, if you want to go to the next slide, Cece, this is all kind of leading towards the creation of this network and the kickoff event that's scheduled for June 1st to the 3rd. I see Stephanie Schmitz is here. She's going to be facilitating a workshop on psychedelic archival research, and she just turned her camera on. Yay, hi. With her expertise as the archivist at the Betsy Gordon Psychoactive Substances Research Collection at Purdue University. So we're really excited for that and to get you all more information about that. And then of course our kickoff event, which you'll learn more about as time goes on. You can stop sharing if you'd like, or go back to the first slide, Cece. And so we'll just kind of jump right in, and I'll give a quick introduction of Dave and Tom before we hop into our first primer. And so David Casimir is a patent attorney with Casimir Jones, an intellectual property law firm that specializes in biological and chemical technologies. David has a bachelor's degree in cellular and molecular biology from the University of Michigan, a master's degree and PhD in biochemistry from the University of Wisconsin, and a law degree from Stanford University. In addition to his legal practice, David teaches at the University of Wisconsin Law School and has guest taught courses at the University of Wisconsin Business School and the University of Michigan School of Pharmacy. He is also one of the co-founders of Porta Sophia. And then Tom Isenbarger is a shareholder and registered patent attorney at Casimir Jones, SC, an intellectual property law firm in Madison, Wisconsin. He received a PhD in biomolecular chemistry at the University of Wisconsin and a JD at the University of Wisconsin Law School. So prior to attending law school, Dr. Isenbarger was a postdoctoral fellow in the Department of Genetics at Harvard Medical School and in the Department of Molecular Biology at Massachusetts General Hospital, and then was a postdoctoral scientist in the Department of Bacteriology at the University of Wisconsin. So people with a lot of expertise and knowledge that is just like perfectly suited for what we're up to here with Porta Sophia. And so I'll prompt Dave and Tom with a series of questions to help make our way through the least you should know about patent law and prior art, in order to better understand what we're up to at Porta Sophia and with the Archival Researcher Network. And again, if you have any questions or anything as we go, feel free to pop those in the chat. We'll hopefully have time for some more structured Q&A at the end of the session. So again, the kind of two big topics here today, and the title of the session is Patent Law and Prior Art. So we're going to get started with this idea of patent law. So the first question is, I'd love for you, Dave and Tom, to kind of talk about the origin of and sort of the general logic of the patent system. So both in terms of perhaps the theoretical benefit to society in the logic of this patent system, as well as how it can be a detriment.
Sure, I'll start off there. So patent systems in some form or another have been around as early as the 1400s. They started in Europe. But the general premise of them is that people will create ideas, and some of those ideas have value, and some of those ideas to get out into the world in a way that people can use them most effectively and share them most effectively require investment, and also that there's some level of sort of a moral right to the creator of an idea in sort of possession of that right that they came up with. And so there was a recognition that the government should protect in some way those ideas. And in exchange for that, there must be a sharing of the idea so the world can learn about what was done and and build the next best thing. And so in the United States and many other countries, the governments created legal regimes for protecting ideas. And that shows up as a general category called intellectual property. Patent law is one subset of that protects like machines and devices and drugs and methods and processes. And essentially the concept is, if we give someone a monopoly, which we, governmentally we're supposed to generally be opposed to, for some limited amount of time, it will incentivize people to innovate more and share that information more. So that was the goal, sort of the righteous goal, which is if you create the system, more people will innovate and more people will share that information. On the downside, as with any sort of government-created system, you can have some abuses of the system. And because it's managed by human beings and human beings are fallible, you can have mistakes made in the system. And sometimes those mistakes can be very consequential. The way the United States law was set up, when someone gets a patent, they, by government right, have the exclusive ability to say who can make, use, sell, or import a particular innovation. And use is a really important term in there. Basically, if someone has a patent on a thing, without their permission, no one else is allowed to use that thing, as well as make it or sell it or import it. And so it gives quite a bit of power to the patent holder. And so if someone is given those rights by mistake, we've got a problem.
Great, thank you so much, Dave. And feel free to jump in, Tom, if you want to add anything at any point. But sure. So yeah, I think sort of a rule of thumb might be something along the lines of, in some cases, good patents have the capacity to make technologies more accessible to the public, yes, and perhaps bad patents would be the opposite of that. Would that be fair to say?
Yeah, so go ahead.
Yeah, I'd say in a way, following on what Dave said, part of the this policy that he discussed is the exchange is incentivizing people to share their ideas with the world in return for a limited monopoly or right to that technology for a limited amount of time. And so in one way to think about it is that so-called bad patents might be ones where that relationship, someone is taking advantage of that relationship and trying to manipulate the system so that they're accumulating wealth or property without giving back to the public in return, according to that deal that's set up the patent system. Where a so-called good patent might be someone who is adhering to that contract, if you would, where they are giving to the world their technology and then keeping their rights within the limits of what they're giving to the world. It's in cases where people are trying to take rights to things that they did not develop, or broaden rights beyond what they've developed. And those are instances where you can start talking about whether something is good or bad, or is an abuse of the system. And in economic terms, you can often think about this in terms of something called rent seeking, if you're familiar with that term. So I think that is one way to think about it, and in a sort of policy or theoretical framework as far as what this system is set up to do and how people can abuse it.
Yeah, thanks. Yeah, so as a psychedelic prior art library, which is sort of a mouthful, but Porta Sophia really seeks to kind of intervene in the patent prosecution process to protect technologies in the public domain. Well, also part of our mission is also stimulating innovation, right? The same logic by which the patent exists, right? And supporting good and ethical patent practices. So hopefully, I'm wondering if you can talk a little bit about why this is especially an important challenge in the world of psychedelics, and maybe thinking about some of the origin of Porta Sophia being kind of some bad patents that did kind of come about early on in the psychedelic space, and maybe some strategies of bad patents and how you would know if something is quote unquote a bad patent.
Sure, yeah, and I think understanding a little bit about how the Patent Office reviews patent applications is important here. And so when the law got set up to say someone may be entitled to this patent or this monopoly, it's a very serious thing for the government to grant to someone. A set of conditions were set up. They have to check certain boxes to qualify for that right. Two of the most important boxes are that the innovation has to be new and non-obvious. So they has to have done something that no one did before. And with that in mind, the way it works administratively is someone believes they invented something. They submit a document to the Patent Office. The Patent Office has a reviewer look at that, and it's typically someone with a technical background in the area of the innovation. And they do searching and analysis to see if it in fact is new and non-obvious compared to what came before. Generally speaking, what the Patent Office typically looks at is printed publications, oftentimes databases with peer-reviewed publications, earlier patents. They're free to look at everything, but there's the reality of the way the patent system is set up is they're given very little time to do their analysis. So there tends to be a trend that they largely focus on a set of established databases and largely focus on printed publications, typically peer-reviewed databases, and patents. And so why that's a problem in the psychedelic space is we have a multi-decade window, in some cases much longer, where a lot of the public knowledge about these compounds or natural materials that contain these compounds does not appear in traditional peer-reviewed literature or in patent databases. So when the patent reviewers try to identify whether, say, an idea like using psilocybin to treat depression is new or not, they may or may not find that in the places they're looking, but it's out there. And so what Porta Sophia recognized is that there were a number of these patents starting to issue that should have never been granted, because we knew from our own internal expertise that they were claiming things that were not novel. We had a problem, and looking at the problem, looking how the examiners were reviewing this, we saw that they weren't looking in the right spots. And then recognized that it wasn't easy for them to look in the right spots because the right spots didn't have very clear arrows pointing to where they are. And so Porta Sophia came about as with a primary mission to create all of those arrows and to compile all of this information to make it very easy for patent reviewers to find this material. And then as Porta Sophia developed, to be even more proactive and to directly hand it to the patent reviewers who are looking at these applications and saying, here, consider these 8 prior art references when you're looking at this particular patent application.
Thank you. So I wonder if you could give some examples of the ways in which patent examiners' limited time and expertise might be exploited. So things like too broad of claims, right? So what exactly, of course I know the answer to this question, but like starting to get a sense of what we do in Porta Sophia, and the first kind of step in that workflow is really getting a sense of what patents are out there. And the, I guess if you could just talk or speak to the sorts of things that we're looking for as red flags in patent applications.
Sure, yeah. So many of the things that I talked about previously, you know, there are instances where, you know, based on our own knowledge or an expertise, if someone is trying to protect something that looks like it's overbroad or it is not new, or it is a trivial tweak or change of something that has been known before, and there are many ways to do that, but those are the general classes of things that we would see as problematic. And you know, the flip side of that is that if there's something that's truly innovative and inventive that is helpful for people, you know, that's fine, you know, but there are obvious instances where that's not the case, where you look at something and you think, well, yeah, that probably should not be patentable. And so I think one of Porta Sophia's goals is to sort of intervene at that initial stage to provide people that might have an idea for a technology and give them the resources to then assess whether or not what they're thinking about or what they're developing is patentable. You know, so it's a resource that can even come in before the patent process starts for people to get an idea of what their chances are of being successful or not. And it can also be important for people that are investing in these types of technologies to understand the worth of what they may be investing in as a due diligence step and sort of kicking the tires of possible technology. So I think eventually it can be very powerful from that standpoint, you know, before the patent office is even involved. And then, as you mentioned, you know, at some of the early stages of the patent examination, there are ways where we can get directly involved with informing patent examiners about particular pieces of prior art that may help them.
And I'd say a couple, you know, real life examples we've run into. There are some red flags for certain types of patent applications that people are processing. So some of them are very clearly just ideas where they didn't, there's no data, there's no sort of empirical work that went into it. What it looks like with these patent applications is people were just sort of throwing out lots of ideas and hoping they could sort of get a patent on whatever they could get, perhaps taking advantage of the limited ability of patent examiners to find these things. And then we've also seen people sort of use creative language about how they're claiming the invention to perhaps make it more challenging for the examiners to find or identify the right prior art. And just to give an example of that, something that would be clear is treat a patient with this disease with compound X. You know, that's kind of a straightforward claim. What's a little harder for the examiners to deal with is if you say claim that mechanistically, like said, treat a patient with this disease by giving them a compound that interferes with receptor Z in a manner in which, you know, the receptor activity is increased 50% or more, right? It's just something that, you know, if it were peer-reviewed literature you were looking at, it'd be easier to find. But even if you're looking at some of the harder to find prior art out there, it's a kind of a sneaky way to word it. So some of the things we're doing too is identifying some of this non-traditional prior art, things that might be in archives and other places, and then also positioning it in a way that it's very clear exactly what it's describing. So if it's inherently describing something that would trigger a particular biological mechanism that might not have been known in 1920, but we know now, not letting someone sort of get away with those tricks.
So thank you so much for that. I'm going to back up for just one second and ask you to define what prior art is.
Yeah, a little tricky here, but
and
I'll
examples too.
Yeah, I'll give a general description of what it is, and then I'll give the legal description. So the general description is it's sort of all the public knowledge that was present before someone filed a patent application. So prior art, prior means prior to the date they filed their earliest patent application. Art is kind of an odd term here. It's actually a very old term that was used in the late 1700s, sort of Enlightenment era, to refer to sort of the scientific discoveries and technical arts. And that history sort of carried forward. So people tend to think about paintings and music when they think about art, but it's an old term that referred to kind of technology. And so prior art is public knowledge from the past. Legally, it's a little trickier because for example, in the United States, what counts as prior art against a patent is defined by the law. And there's like what we call statutory language, and it lists specific categories like printed publications, patents, public uses, sales or offers to sell a particular thing. And then the patent law changed fairly recently to throw in a catch-all that basically says anything otherwise available to the public, which is kind of vague. But when you look at the court decisions, at least in the United States around that, what it essentially means is anything where someone in the technical field of the innovation would have been able to access it, even if it took a little trouble to access it, even if it was obscure, if they could get to it, that counts as prior art.
So for instance, if there's a single copy of a thesis in a department basement in Munich, that's considered prior art because somebody could theoretically find that and go get it. Question of what's accessible or public might come up in if someone gives a presentation to 5 people in an auditorium that are under a non-disclosure agreement. Is that public? But what if there are 1,000 people? So there are gray areas, and it's largely, I think, concerning the question of what's public and what's accessible.
Thank you, guys. So I know we're running a little bit short on time here. We wanted to keep these sessions nice and brief, so it didn't take too much of your day since there are 4 of them. But rest assured that we will get much more into Porta Sophia and our kind of behind the scenes, what prior art search looks like for us and how we kind of put together our library, as well as a little bit more about our more direct action with the third-party submissions that we're doing with the patent office. And yeah, I think you'll get a better sense next time too of how the Archival Researcher Network is really going to be positioned to make our prior art library more inclusive of key archival sources in the history of psychedelics. And so yes, I'm going to open it up for questions, and I saw that Nancy Campbell has a question in the chat that maybe we can start with. And just a quick note that this is recorded, and we're going to be posting the sessions, all the information sessions, to YouTube, and we'll share those with everyone that has registered. So you can also then continue conversation in the YouTube comments theoretically as well. But yeah, so do one of you want to kind of take that question in the chat from Nancy Campbell? So the question is there a process by which patents wrongfully granted may be reviewed?
Yeah, sure. There's sort of 2 main ways people can challenge an already granted patent if they believe it was wrongly granted. The historic way was through courts, having a litigation to fight about it. That's an extraordinarily expensive process. The good news is the United States relatively recently created what's called a re-examination regime, where anyone other than the patent owner can challenge the patent in the patent office again in front of a set of expert judges, not just a single reviewer, but 3 reviewers, to say, we think you got it wrong, take another look at it. I will note that's also still a somewhat expensive process. So we've got some asymmetry in the system here that it does take some non-trivial resources to mount such a challenge.
Other questions, feel free to put them in the chat and or just raise your hand or unmute yourself. And I can read Jack's. So will all of the ARN participants receive the same list of prior art targets, or will it be broken up? Good question. We'll get more into those logistics definitely at the next session and probably the last session with Luke. But I think the answer is yes. And you'll have a chance to kind of lay claim to, or kind of articulate which ones that you might be interested in. And part of my role is to kind of connect people to others that are perhaps looking at the same targets and making sure that there's no redundancy and that kind of thing. Or at least those folks that are interested in the same things are connected to each other to work together. Other questions? Okay, Stephanie, I can read your question if you want. Okay, so are there specific patent examiners that specialize in psychedelics? Like, are you getting to know them and get a sense of what kind of information would be most useful to them? Great question.
Yeah, I can start off at least with this one. Yes, there are. The patent office is divided into bins of expertise. They're called technology groups or technology centers, of groups of examiners that say are, reviewing automobile parts, and one that's reviewing drugs, and one's reviewing, whatever the different fields are. So there is a subset of examiners that we have identified that are typically reviewing the psychedelic patents. I don't know their names, but there's a way to find that out. When you look at a published patent application, it lists the examiner that is examining that case. And there seems to be a small group of them that are involved with most of these patents.
Yeah, and in fact, one of the early things we did when we recognized this problem, we wanted to get a feel for what is the scope of the problem. So we systematically identified every publicly accessible patent and patent application in the field. We're primarily looking at a couple drugs to start off with to get a feel for the problem. And as part of that analysis, we made a list of which examiners were handling which cases. And it came down to a short list of about 5 to 7 examiners were handling most of these cases. And so over time, we will end up having quite a relationship with them. Under the rules, we're not allowed to directly talk to them when they're handling someone else's applications. We can submit prior art to them. But as that process goes on and we see what they're picking up and what they're doing, and we're monitoring these processes all the way through, we'll learn a lot about what they need, and we can get them what they need.
I think is it also the case that there are some patent families that are significant within this space that are assigned to one particular person that keeps coming back to them? Can you say a little bit about what a patent family is?
Yeah, so the patent families end up being sort of this controversial topic. What a patent family is you typically start with one patent application on a particular technology, and then over time, it builds out into multiple patent applications. And there's a lot of different ways you can do that. But just to give you a feel for the extent of how broadly this can happen, if you look at very, very valuable technologies, say classic big pharma drug type patents, it's not that unusual to see an initial patent application turn into a family that might have 20 or 50 or 100 patent applications or patents associated with it. And some of those are ones that are filed later on to try to extend the lifetime of the patent, where they're making small changes to a compound, for example. Some of those are just refiling the original patent application to pursue different aspects of the invention. And that's a little known part of the patent system, is when you file this document, you're not limited to a single patent. You can proliferate it out like a cell divides or branches of a tree. So an initial filing can turn into multiple different patents. And those tend to go to the same reviewers. But some very aggressive patent filers use that as a process to try to overwhelm patent examiners and to try to diversify their chances of getting a weak thing through. You know, if you file 10 examples of something and 9 of them are shot down, but one of it makes it through because of just the statistics of how humans behave, getting 1 patent through can be enough to cause a lot of trouble. So sometimes you see these big fat patent families filed as a mechanism for upping the probability that something gets through where it may not have otherwise.
Thank you so much. And I want to be respectful of folks' time. So I know we're at 12:30. I'm going to stop the recording. I think most of us, Dave, Tom, myself, and Cece can stick around for a few minutes if there are other questions. And I think I see a couple more in the chat. But thank you all for being here. And I'm super happy to answer questions via email too. Stop the recording.